to the disco if our very basic human rights are not being met, such as access to justice. Thank you.
Thank you, Al, and thank you, Fiona, for the very powerful stories and images you've provided to us this morning. Sadly, again, the scenarios that you've painted are stories which we heard in our consultations, and they're very powerful stories. But the images that you have provided for us this morning are very potent as well. Not the images of your disabilities, but rather the images that people with disabilities, with the right support and communication equipment, should and can be heard by the justice system in an equal way to all other Australians. So thank you both very much for providing those images and stories to us. Last year, as Professor Gillian Triggs has mentioned, the Australian Human Rights Commission made 20 Years, 20 Stories, a series of short films depicting the lives of Australians with disabilities. One of those films tells the story of Marlon Noble, a story very relevant to this report. Let's watch that story now.
I'm Marlon Noble. I'm 30 years old. I live around York. I'm originally from Carnarvon.
The image of the bearded Aboriginal man freezes, fade to black, text Marlon Noble presumed guilty. Marlon and a burly, bearded man load motorcycles onto a ute, then drive through a sun-drenched suburb. As they drive along a highway lined with low scrub, Marlon waves from the ute. Marlon puts on a helmet and rides his bike onto a beach.
At age 30, Marlon Noble is just like most guys.
Put my bike out today in the Grenoble. My bike died on me. My bike died on me. I'm not happy today. I'm not happy man. I love my nickname, boys. Tell you. You know that laugh like this. I Eagle Knievel.
But Marlon's life has not always been so carefree. At the age of 3, he suffered from a bad bout of meningitis that left him mentally impaired. But his disability rarely got him down. Being a part of a large family, Marlon lived a happy childhood. Then, at the age of 19, Marlon's life took a drastic turn for the worse.
He was charged with sexual abuse of 2 girls. And one had intellectual disability and the other didn't, and they were Aboriginal girls. I mean, friends of the whole family.
From the very beginning, Marlon denied doing anything wrong. But due to his disability, he was deemed unfit to stand trial. That left him in a legal grey area. The courts ruled him ineligible for full-time psychiatric care, but too much of a risk to the community to be released. So, Marlon was jailed indefinitely.
And I like it, jail. And I like it in there. Scary place. You don't have families in there. No brothers or sisters talk to you. You're on your own. And your own.
Headlines read, man in jail 10 years without conviction. Australian man spends decade in prison without trial.
After a full decade behind bars, fresh evidence emerged. Ida Courtois, who'd taken Marlon under her wing after the death of his parents, discovered major holes in the evidence against him.
Having spoken recently to the girls and their mother, the mother didn't even know that they were complainants to any charges. And she vehemently says nothing happened, and the girls say nothing happened.
I'm not guilty. I don't do anything with that girl. I don't nothing with that girl. He accusing me. I'm not guilty.
After a series of damning headlines, all charges against Marlon were dropped, and Marlon was released. It was a day he'll never forget.
A photo shows a beaming, mud-covered Marlon on the beach.
I think that beach, I'll go out of the jail, man. I'll dive in the water. Top of the water. That's my name on it. I'll dive in. Ah, beautiful, brother. Lovely sunny day. Lovely beach. Lovely birds and smelling lovely sea.
Marlon and the burly man sit in a cafe.
But Marlon's is a strange kind of freedom. Although still never convicted of a crime, he remains under 24-hour supervision.
Well, he's got to be with a support worker all the time. He's got to be in line of sight all the time. For someone that hasn't been convicted, why? Why does he have to be in line of sight when you haven't been convicted of anything? I don't think Marlon's guilty at all. Not hope in hell.
He is still seen as a convicted prisoner who committed horrendous crimes and who has an intellectual disability.
I'm not a free man yet for a little while. I can't walk down the street by myself. I can't walk down by myself. I can't do it. I can't have confidence for myself. I can't have lunch for myself. Went wrong. It hurt me.
Never convicted, but never fully freed, Marlon's case highlights the inequalities that still exist within our legal system for people with disabilities.
10 years in jail without charge is just not on. It's just not on. It's absolutely disgusting.
Around Australia, there are a huge amount of people in exactly the same position as Marlon. People are imprisoned and never been found guilty of a crime. There's not even any compensation for them. Because what they did was lawful. And that's the scariest bit, I think. But that law's still there and it's still happening. People are still being imprisoned indefinitely.
Black and white footage shows Marlon gazing gravely into the camera. Text on screen: the Australian Human Rights Commission is working to ensure that people with a disability receive better access to the justice system and to prevent the occurrence of stories such as Marlon's. Credits: presumed guilty, director, camera, editor, Paul Bell, Feral Films, online producer, editor, Leslie Hahn, supported by DADAA, funded by Lottery West, copyright 2013 Australian Human Rights Commission. 20 Years, 20 Stories is a partnership project between the Australian Human Rights Commission and the Sydney Community Foundation. We would like to
I'm pleased to have the opportunity to speak about this Australian Human Rights Commission report today, Equal Before the Law, Towards Disability Justice Strategies. We've already heard some stories of how people with disabilities don't receive equal treatment before the law. Let me tell you a few more. Maria has cerebral palsy and little speech. She wanted to tell police about a sexual assault, but there was no communication support worker to help with the statement. The police relied on Maria's parents to provide communication support. Maria was uncomfortable giving personal details of the assault to police in front of and through her parents, so her evidence was incomplete. This caused problems for the investigation and during the court process. Another story, and this is a quote. Our daughter loves pretty calendars and greeting cards. In her 30s, she has an intellectual disability. She lives independently. During a 4-year period, she was convicted of shoplifting such cards 7 times and was at risk of going to jail. She was only convicted because the unfit to plead laws in Queensland do not apply to summary offences. Third story. Henry has an acquired brain injury. He wanted to apply for support from legal aid to appeal his conviction and needed help to fill in forms. He found the language complex and difficult to understand. He didn't receive assistance in prison to fill out the forms and filled them out incorrectly. This delayed his application. By the time he filled out the forms correctly, his application was outside the time limit. These and many more stories were drawn to our attention during our consultations last year. Australians with disabilities, particularly those with communication challenges or complex support needs, do not receive equal treatment in our criminal justice system. This is true whether they are victims, witnesses, or alleged offenders. This results in a number of things. Negative outcomes, including increased chance of being victims of violence, difficult experiences with police, lack of time and understanding in the court system, higher rates of incarceration, and higher likelihood of longer time in jail and reoffending. This is a problem for all of us. Not only is more damage done to people with disabilities who have negative experiences in the justice system, but because such people spend longer time there and are not dealt with appropriately, it increases the cost to the whole community. As you know, we consulted Australia-wide in capital cities and regional areas. We spoke with people with disabilities, their families and advocates, practitioners from police, the courts and correction systems, and attorneys general. The problems we heard about are complex. They include negative and limiting assumptions being made about people with disabilities, lack of understanding of people's capacity, lack of appropriate staff training and resources, lack of time to address more complex issues, and some problems in laws and the ways that they are applied. The problems cannot continue. 90% of Australian women with intellectual disability have been subjected to sexual abuse. Just think about that, 90%. There are currently at least 20 to 30 people in our prison systems who, just like Marlon, have not been convicted of an offence. They've been found unfit to plead, and jails are the only accommodation option. From 1989 to 2011, 105 people were shot by police, and 42% of those people had a mental illness. For every $1 spent on diversion from the criminal justice system, between $1.40 and $2.40 in government costs could be and is saved. Big money when the Australian community spends $11.7 billion on the criminal justice system. Sadly, the Human Rights Commission has not found the silver bullet. I wish we had. Our report lists programs and services currently in place which provide better access to the criminal justice system for people with disabilities. And it proposes the development of disability justice strategies in each state or territory. These strategies, along with the resourcing they will require, must be developed in partnership with people with disabilities, must provide for better coordination of services, and must recognise the impact of disability within the justice system. The strategy should focus on these outcomes. 1, safety of people with disabilities and freedom from violence. 2, effective access to justice for people with disabilities. 3, non-discrimination. 4, respect for inherent dignity and individual autonomy, including the freedom to make one's own decisions. 5, full and effective participation and inclusion in the community. The principles and actions in such strategies should address, firstly, appropriate communication, secondly, early intervention and diversion, thirdly, increased service capacity and support, appropriately resourced, fourthly, effective training on disability, particularly violence and abuse, recognising the particular impact of gender-based violence. Fifth, enhanced accountability and monitoring by people with disabilities. And sixth, law and policies which address the intersection of disability and gender and improve understanding for service providers. Our report, as I said, in an appendix, lists programs and services which are providing a better justice pathway for people with disabilities. The list is not comprehensive, and we would welcome additional suggestions to add to that list. Because the report and its appendices are online or are an online resource, these additions can be easily made and booked. I'd like to thank the Commission staff and contractors who've worked with me on this report. I'd like to thank Eileen Baldry and her team at the University of New South Wales for the work that they did on costs of access to justice. And I'd like to thank John Walsh and his team, well, his then team, John, at PwC. I'd like to thank Daniel Creasy and his team at DLA Piper for their support. Without them, the consultations and the supporting documents online wouldn't have been such a rich resource. I thank the politicians, leaders and staff in the various areas of the criminal justice system with whom we spoke. I thank the representatives of community organisations for their honesty and detailed responses. But most of all, I thank all of the Australians with disabilities who took the opportunity through consultations and submissions to have their hand on the wheel of change, which has much turning to do in order to achieve equality before the law for us. If someone is a victim of a crime, Australians would expect the system to respond. If someone seeks to give evidence in court, Australians would expect that to be facilitated. And if someone is accused of a crime, Australians would expect them to receive fair and equal treatment. Our criminal justice system is not meeting those expectations for people with disabilities. That must change. I'm pleased to launch this Australian Human Rights Commission report and trust that it sets a foundation for better justice pathways in the future. Thank you very much. Now, I'm happy to take questions either from media or those attending on the report. And after some questions, we'll bring the function this morning. We have a couple of people with roving microphones. If I could get people asking questions to use the microphones, because it will facilitate the signing and the real-time captioning. Who'd like to ask the first question? It's always hard to get the first question.
Graham, Dan Stubbs from the Inner City Legal Centre. There's some great recommendations in this report, and I wonder what processes do you think, what steps do you think are next to try and hold the wide range of agencies and levels of government who are accountable for delivery on these human rights, because this is, in some ways, is really the first important step in bringing this to the attention of a lot of agencies which need to be held accountable.
Thanks, Dan. Well, certainly the Australian Human Rights Commission, I am sure, will be involved in working with agencies throughout the justice system in Australia to address the recommendations or the justice strategies proposed in this report. However, and I can assure you that until the end of my term as Disability Discrimination Commissioner, I'll be strongly leading that work. However, we are a very small under-resourced federal agency in the context of the justice system as a whole around the country. And also, I'm sure that community organisations who work in this area will use this report as an advocacy tool, but such organisations are equally under-resourced and stretched in the work that they need to do. I will be seeking in the next few months to meet with every Attorney General in Australia to talk to them about this report and to encourage them to devote resources to the development of the strategies which we've recommended. And I believe that ultimately Attorneys General and the heads of various justice agencies are the people that we have to hold accountable.
Graham Simpson from Council for Intellectual Disability. Graham, as you well know, I've often seen the complementarity of roles between the justice system and the disability service system as being really essential. It's often struck me that the courts will send people to jail not because they want to, not because they're quite frank about it. It's not because they want to, but because the person lacks the support they need to meet their disability support needs, which indirectly then has the effect of encouraging the court to think the person's not going to just reoffend straight away. The National Disability Insurance Scheme is obviously a massive step forward in terms of provision of disability support. I'm interested in your thoughts about the role that the NDIS has in this space, either central to the recommendations in your report or complementary to the role of justice agencies.
Thanks, Jim, for that question, and your observation is absolutely true, that the complementary role of disability service sector is critical to changing the situation that's been outlined in this report. And in the report we make references to the National Disability Insurance Scheme, and it was certainly an issue that was raised with us on many occasions during our consultations. It's one of the reasons that the report proposes the development of disability justice strategies, because one of the gaps that we saw was the gap that you've described between the justice system and the disability support system. And courts being put in the terrible situation where they determined or chose jail because there just weren't appropriate alternatives. So not only is this a responsibility of Attorneys General and justice agencies, but it's a responsibility of disability service ministers and disability service agencies. And in the centre of that is the National Disability Insurance Scheme. And the scheme has a significant responsibility to support people with significant disabilities, the 400,000 or 500,000 people in Australia who will fall into the support provided by the National Disability Insurance Scheme. And that support must be provided on an equal basis, whether those people are victims of crimes, other participants in the justice system, or alleged or determined offenders. And so the links to the prison system must be made by the NDIS so that people with disability can receive appropriate NDIS supports. Inevitably there'll be a problem because the disability service system will push back and say it's the justice system's role, and the justice system will push back and say it's the disability service system's role. We have to stop those games. We have to recognise that real people are falling between that gap. And we have to develop strategies with the combined support of all of the agencies so that that gap is removed.
Graham, Patrick McGee from the Aboriginal Disability Justice Campaign. Graham, you'll know that avenues of redress for this group of people who have been subject to indefinite detention in the criminal justice system are few and far between. DJC has lodged complaints through Philip French's Disability Law Centre, both at the UN level and at the federal level, and at most state discrimination commissions or healthcare complaint commissions. In all cases, those complaints have taken between 1 to 2 years and have yielded pretty much nothing for any of those people that the complaints were made about. Given that that's the only avenue of redress around getting a system that doesn't meet the needs of people with disabilities, what do you think needs to happen within our human rights legislation to in fact effecting a timely response from the human rights perspective for this group of people?
That's a very big question, Patrick, but thank you for it. I think we need to do a range of things. There were proposals to amend human rights law considered by the previous government, because we all know that whilst the complaints system that we have is the system across the board for discrimination in a range of areas, that it does not remove, it reduces, but it does not remove the power imbalance between complainants and respondents, unfortunately. But at the moment, that is the system that we have, and then of course there are further problems which mean that the complaints can't be lodged under disability discrimination law and Australian human rights law, and need to go to the UN. I think we need to do a range of things, and one of the first things that we need to do, and I was pleased to see and pleased that Gillian earlier welcomed Professor Rosalind Croucher from the Australian Law Reform Commission here, because as well as being involved with this report, I've been working as a part-time commissioner with Ros on the Law Reform Commission's inquiry into capacity, and that inquiry is ongoing, and it will bring out a draft paper of its recommendations later this year, and then a final paper. And it's really important that that people in the justice sector and in the disability sector continue to contribute to that paper. Because one of the problems that I saw in the ALRC consultations that have taken place so far, and in the consultations which the Australian Human Rights Commission ran, was the way in which capacity of people with disability is viewed. And it's viewed in a very limited and negative way because of the way that disability is viewed by our general society, and it's viewed in the same way. So I think, as well as the important recommendations that the ALRC will ultimately make and implementation of those recommendations, we need a huge cultural change in Australia in terms of the way disability is viewed. And that's only going to come about by the continued work of advocates such as yourself, Patrick, and the many others who are in this room. I mean, it's disappointing to me that we have had, in relative terms, very little media so far for this report. Now, that may change, but the only place that this report's been in the general media so far that I'm aware of is the ABC Radio and ABC Online. So that tells us of the size of the job that we have to do. It really does. But, you know, that is the job that we have to do, and those of us involved in doing that job have to just keep on with it. But the size of the task is very large, as you've outlined, Patrick.
Good morning, Graham. Commissioner and your team, good morning. My name is Colin Allen. I work with the Deaf Society of New South Wales, and I'm also the President of the World Federation of the Deaf, and I am the Vice Chair of the International Disability Alliance, otherwise known as IDA. So I do have 3 different roles that I occupy. I'm Australian and proud of the report, and it's wonderful and a very significant report, especially for people with disabilities who have barriers to the justice system, ongoing barriers. I'd like you to look at this sign. What I'm actually doing is I'm putting up a hand like a blockade, and then another hand that's trying to get past that just can't. So that's our sign for barrier. and we need to really bulldoze that blockade. So I hope one day in the near future that will happen. As a deaf person using sign language, that is the key for people in the deaf community to access the justice system. And as our chairperson, Al, mentioned, Alistair McEwen, sign language is significant to our community. And in terms of the Australian Human Rights Commission, you may have noticed if you've come along to many of their events that they are always providing sign language interpreters for us, which is wonderful. So today, I just call on you to be aware of a deaf person's need in terms of communication support. A deaf person might need captioning, that might be their preferred mode of communication. Maybe it will be through oral communication or through Auslan, Australian Sign Language. And you need to find that out from the deaf person themselves. And there are many different ways that a person accesses communication, and I really ask you today to think about that. And thank you very much for the report, and I wish you all the best.
Thanks, Colin, for those eloquent comments. I don't think I have much to add except to say that we met with a significant number of deaf people throughout Australia during our consultations, and they were very significant and positive contributors. I think we've got one more question.
Graham, it's Stephen Gianni from AFCO, the Australian Federation of Disability Organisations. And you've talked about, and the report covers extensively, issues as they relate to people with disabilities who are witnesses and offenders, alleged offenders, and victims. Of course, the report needs to take a very strong human rights framework and use that, as you always do, from your position here at the Human Rights Commission. I'm wondering, though, if you've got anything to say about any potential long-term change that might be possible. If we were to see people with disabilities holding down more roles, positions of authority and leadership throughout the justice and judicial systems in all of the jurisdictions in Australia. And if it's possible that by doing that, we might see longer term and more deep-seated change in broader areas that justice affects.
Thanks, Stephen. My colleague Elizabeth Broderick, who's here today, has been a champion of the cause of ensuring that women get into more leadership roles across the board, because she recognises, and this is a view that both I and the Australian Human Rights Commission, I think it's fair to say, Gillian, share, and that is that one of the most powerful and potent examples of what people from a particular group of people can do, whether it's women, people with disabilities, people from different backgrounds, older people, and I'm not sure if my colleague Susan Ryan's here as well, but yes, she is, and she would say the same thing, I'm sure, that one of the most potent ways to change the thinking about groups such as that is to have demonstrable examples of people succeeding in those roles. And Susan's Age Positive website that the Commission hosts is just another example of that. Undoubtedly, what you say is right, Stephen. But I don't know of too many people in judicial office or in senior justice roles around the country with disabilities. I know that Professor Ron McCallum, who's also here, has just been appointed to the Administrative Appeals Tribunal, and that's great. But we need to have a lot more people in those sorts of roles demonstrating their capacity and changing that perspective. some of you might suggest that coming to the end of my term here at the Commission, that's a bit of a plug for looking for a job after July, but I can assure you it's not. It's a strongly held view that I've had all the time that I've been a Commissioner, and that's the way we change views of how disadvantaged groups are perceived. We've got 2 more questions quickly, I think.
Graham, it's Kane Becker.
Getting my instructions here, Kane, yes.
Graham, it's Kane Becker from the New South Wales Disability Council. In New South Wales, at least, there is a draft piece of legislation at the moment, the Disability Inclusion Bill, which includes, I think for the first time, a legal requirement for all agencies and councils to produce an action plan and to provide those to the Disability Council. I'm just wondering, in terms of that process and the fact that a number of us are producing submissions on that draft legislation at the moment, whether you have any thoughts on how we can use that or how that might leverage around other jurisdictions.
Well, I think it's a positive initiative, Kane, although my understanding is that state legislation has required the production of disability action plans for some time, and that they can be lodged with the Australian Human Rights Commission. But I'm very happy for your council to be accepting and examining those plans. I think the development of such action plans are an important first step, but it's only a first step because what happens, unfortunately, to many such plans, not just in the area of disability, is that there's a lot of plan but not much action. And I think that the key thing is that agencies that complete those plans need to build disability into all of their agencies' work. One of the things that we've just done at the Australian Human Rights Commission is that we've combined our various plans. So we have a disability action plan, we have a reconciliation action plan, and we've combined those into the one plan. And the reason that we did that is because we think it will give us the opportunity to have more of a focus on the various strategies that those plans come to guide us with, instead of having the plan off in the disability team or the Aboriginal and Torres Strait Islander social justice team or whatever, and get a more mainstream focus. And that's what agencies need to do. I haven't, unfortunately, had a chance to turn my mind to the specific terms of the New South Wales Bill, Kane, but I would encourage organisations of people with disabilities to do so, and if you can use the Human Rights Commission report as an advocacy tool in that regard, then please go ahead. Now, I'm sorry, I think we've got one more question.
Yes, hello, Commissioner Graham. It's Ron McCallum.
McCallum.
And today I'm wearing my hat as a member of the UN Committee on the Rights of Persons with Disabilities. I want to congratulate you and the Human Rights Commission team on this report that I look forward to carefully reading over the next few days. It's not only an Australian problem, it's a worldwide problem. In all the countries with which we dialogue, the issue of failures of access to justice, of sexual violence against persons with disabilities, particularly women and girls with disabilities, have been uppermost. I'm delighted to see this report and I hope governments will take notice of it. And finally, Commissioner, may I congratulate you for speaking before the committee when Australia was being dialogued with last year, for speaking with an independent voice as your role as Commissioner under the Human Rights Commission for persons with disabilities. Thank you.
Thank you very much, Professor McCallum or Ron, for those very generous comments. I think we don't have any further questions. So this brings our event, the formal part of our event, to a close. I thank all of you who've attended and who've participated in our consultation process. We have a long way to go, as I've said in my comments, if Australians with disabilities are to find their rightful place as equal before the law. The Australian Human Rights Commission trusts that this report will set the path on which that journey can be taken. Thank you for your support in the consultations and for your recognition of the report today. Please take advantage of the report as an advocacy tool, and very happy to work with you to try and progress the strategies that it proposes. Thank you very much. We've got some morning tea outside for those of you who'd like to join us. Thank you.